The next part of this seminar on the steps in the small claims court is the question of service. So, what is service and when do you start the service? So, the last module, what portion of the seminar was on the question of drafting the defense or the claim. In the next issue that we're dealing with is the service of this claim. What does service mean? That you're bringing this document to the attention of the opposing party. So let me go back to the question of service when you first commence the action. When you first commence the action, you are creating an originating process, which means that you're starting from the scratch. So what you do is firstly go to the court office nearest to where you are and the rules regarding where you can bring an action. And then in that court, you ask the court clerk to issue it. You take an extra copy and the court clerk gives it a number, and then you have a copy of the claim with a number on it and a seal of the court to confirm that the claim has been issued. Once the claim has been issued, then the next step is service, which means you're trying to bring this across to the notice of the opposing party that you name. If you have one defendant, you have the obligation to bring it to him. If you have more than one, then each of the different people that you're dealing with have to be served, which means you have to give a copy of that claim to that person. So if this is an individual, what would you do? In the case of the person, you figure out where the person is located, and in most claims you have to show the address right in the claim itself, and you tell the process server to take the claim and hand it to that person. That's called a personal service. When you commence an action, the person that you give it to does not know that the action has been commenced until you bring that to the attention of that person, either by giving it to that person personally or giving it to process server who gives it to them. And then once it reaches their attention, then they respond by defense, and if you're the higher court, by appearance or other means. But to bring it to the attention of the defendant is called service. Now, in the small claims court, this service is done by way of leaving a copy to the person or giving it to them personally, and then preparing an affidavit and saying that I have served this person on this date, on this location, and then you need this affidavit to tell the court office that this claim has been served on the defendant. That's called the service. Now, if the person that you serve is a corporation, the corporation is comprised of a number of directors and shareholders, etc. So when you have to serve a company or a corporation, then you have to know that the person you're giving the claim to is a reasonable kind of an authority to whom you're giving it to. And I'm not going through all the details, but in general, it's the directors or person appearing to be an authority who will be in the premises at the head office of the company to whom you're giving. If you're able to obtain a signature, it is helpful. If not, then you are writing an affidavit from the process server to indicate in the affidavit that you gave it to the person who appeared to be an authority or a secretary, receptionist, or a director, and that person accordingly has the duty to bring it to the attention of the corporation, and then you're deemed to have served the company properly. Now, if a defense is filed, you do not have to worry about even the service and the affidavit, etc. Because once the defense is filed, the party is, so to speak, a part of the action. They begin to deal with the action by filing a defense or knowing that you are in the process of litigation and that you have the obligation to respond within 20 days' time to take your position and file the defense. Now, but the important part of understanding the service issue is that the plaintiff, when he commences the action, has a duty to formally bring the claim to the attention of the defendant. The defendant then has a document that might indicate the name of the lawyer for the plaintiff, and you can deal with that lawyer. In fact, if you retain a lawyer as a defendant, then the lawyers begin to deal with each other within the framework of the procedures that are created for them to deal with each other by different means of communication, such as the fax, email, etc., and there are rules for that purpose. But in a nutshell, the question of service is the question of how do you bring a claim to the attention of the defendant. And once the parties have lawyers or paralegals on record, as it is called, whose names are written also on the forms, they can communicate with each other and say, and take the next step forward in the file. So in different words, it's important to understand the question of what is a service, and the word service is a technical word essentially meaning that you brought the action to the attention of the opposing party. And I think that that is very important part for the parties to understand. And if you are a self-represented litigant, it's even more important for you to understand that part, because in the small claims court, very often in many courts today, you will see a very high percentage of the people, even in higher courts, are now going to deal with the issues on their own without lawyers. And that's why for them to understand what the service means is very, very important. And I think that one more thing to say is that if the service is done, then the affidavit of service has to be sworn before a commissioner. And if you cannot find one, the lawyer is usually a commissioner, a paralegal is a commissioner of oath, but the court clerk can be a commissioner, and you can tell him that you serve the document and then file it, and then your filing is completed to tell the court file in the office that you finished one stage of serving the document on the opposing party.